Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. I'm Jaclyn Phillips, and today's episode is Has the Scrutiny Reached a Fever Pitch? Taking the Temperature of Private Equity in Healthcare. Private equity investments are made in all sorts of industries and often act as an important source of capital to help drive growth and success of companies. Antitrust regulators, however, have expressed concern about the potential negative impacts PE investments may have, particularly in healthcare. The FTC and DOJ have been vocal about their concerns and have shown their willingness to pursue novel strategies to investigate and challenge deals that may not have been in their crosshairs in the past. During today's episode, we'll learn about the role of private equity in healthcare, including both the concerns and the benefits, what the current landscape tells us about the agency's approach, and what this practically means for deals going forward. I'm here with my co-host, Jeny Maier. Hey, Jeny.
Hey, Jaclyn. How are you?
Good. Can you tell us who's going to be walking us through all things PE in healthcare today?
Absolutely. I am very excited to have Carla Hine. Carla is counsel in Weil Gotshal's Antitrust group in DC, where she focuses her practice on merger clearance, joint ventures, and compliance with the HSR Act. Carla represents clients before the antitrust agencies and has significant experience in investigations before the FTC and the DOJ. Her experience is across a number of industries, including, and particularly important for today's discussion, private equity, as well as consumer products and construction, energy, pharmaceuticals, med devices, and healthcare. Carla is active in the leadership of the Antitrust section and currently serves as co-chair of the Mergers and Acquisitions Committee. Welcome to our Curious Amalgam, Carla.
Thanks, Jeny, and thanks so much for having me. And before we get started, I just want to note that my comments are my own and made in my personal capacity and do not necessarily reflect the views of my employer or any clients, but really excited to be here and for the discussion.
Thank you. No, we are really excited to have your expertise. And maybe just to set the stage here, could you help us understand what is the current role of private equity in healthcare? How has it developed over the last decade or so?
Sure. So private equity, just to kind of take one big step back, in a nutshell, is private investment in companies that are not publicly traded on a stock exchange. And so what private equity firms do is they raise a pool of money in the form of a fund, they get that money from limited partners. And the fund invests that money by acquiring different companies in which they believe they can generate some return on behalf of their investors. And different funds have different strategies. For example, some private equity funds make minority investments where they don't actively manage the portfolio company, while some funds will acquire a controlling position in companies that they do actively manage. And those concepts will kind of come out a little bit more as we continue the conversation, I think. Some funds will also, just in terms of strategies, will also focus on particular industries, and they build up an expertise in that space. And obviously, one example is healthcare. A fund may invest in or acquire either like healthcare provider entities like hospitals, health systems, physician providers, or companies that provide services or inputs into the healthcare industry like healthcare technology. I think we've seen a lot more private equity investment in healthcare over the past few years because I think it's acknowledged as a sort of recession-proof industry, just given its sort of outsized stake in the economy generally, and everybody needs it.
So maybe thinking of this now from the perspective of a healthcare provider, a physician practice group, hospital, what are the benefits to them from private equity investment?
Sure. So I'll take kind of both sides. One, the investment of the investment by the private equity fund and sort of why they do it, but then also what the benefits are potentially to the target firm that becomes the portfolio company. So obviously a goal of private equity investment is to generate returns for the fund's investors. And one way to do that is to take, what they think is a strong sort of fundamentals of a business and build on it and maximize those strengths that they see inherently that maybe there just aren't enough resources within the portfolio company on its own to take advantage of. So in the case of minority investments, that might mean infusing capital into the portfolio company because the fund believes that that capital could be put to good use to make the portfolio company stronger, maybe perhaps through additional investments in current or expanded products or services, maybe expansion in a geographic footprint. In the case of a majority acquisition where the fund is actively managing the portfolio company, they might take that investment and build out the management team or strengthen the management team or help shape the business's strategic plans or find other ways to make the company more efficient by improving how it operates or providing additional resources, as I mentioned before, to which the portfolio company might not have had access. So, and that might mean like third-party consultants, for example. Sometimes just knowing what resources exist and where to find them is part of, I think, the benefits that a private equity fund can provide to its investments. And then also just helping, them think about longer term strategic thinking. And so sometimes that might mean, again, expanding into new products or services or other adjacencies. And one other way for growth, though, too, is obviously through, I think we've all heard this term now, roll-ups, or what in other FTC DOJ parlance we might refer to as serial acquisitions, basically growth through acquisition. I think more specifically in the healthcare provider context, funds can take on practice management to free up time for providers so that providers can, focus more on actual clinical care or maybe just, spend more of their waking hours or non-clinical hours just having a better sort of work-life balance, for example. Funds may also, provide some guidance on cost-cutting measures to help the practice operate more efficiently, or smaller providers in particular may not have had much access to capital for expansion, or it might otherwise be risky to access capital for them. And a PE fund is just one alternative to infuse that capital and be able to have future potential growth.
All right. So just, thank you. It's a nice, way to think about it that the funds are offering the ability to the target companies or to the physician practices or whomever the recipient of the investment is. It's a way for them to grow, to become more efficient, to expand. So why has this really become a hot topic in the antitrust world? What are we hearing from the FTC and the DOJ about, in particular, the role of PE in healthcare industry? What are the concerns that they have as it relates particularly in healthcare?
Sure. So I think I mentioned before that healthcare spending is a huge part of our economy. It represents roughly 18% of U.S. GDP. I mentioned it's viewed as sort of recession-proof, which is one reason why it's attractive to PE investment, but also sort of belies the fact that it's really important to patients and consumers more generally. And so given healthcare's importance to the economy, it's been an enforcement priority for the FTC in particular for the past few decades. And the role of private equity in the economy is a slightly more recent antitrust related concern. I think back in 2011, we saw changes to the HSR pre-merger notification form to disclose more potentially competitive overlapping investments across private equity funds, because before that, the rules and the form didn't really capture that. And then a few years ago, we started to see a lot more scholarship around common ownership, focused, I think, more on institutional investors or asset managers than private equity. But I think putting the spotlight on private equity was really sort of the next natural step. And I've seen a statistic that private equity accounts for close to 20% of corporate equity in the US, and that's a lot. And so I think what we're seeing is an alignment of a longstanding prioritization on antitrust enforcement in the healthcare industry with another large but largely invisible, I think, to most people, part of the economy. Over the past few years, we've increasingly seen stories about the potential negative impacts of private equity. What happens when you cut too much, you become too efficient. There have been several books published on the topic, a couple of which include the word plunder in the title. So just to kind of give you a flavor for sort of what the public tenor is around private equity, we've started to just more broadly with regards to antitrust enforcement, we've started to move away from a consumer welfare standard focused more exclusively, I think, on whether prices will increase, and something more like a social welfare standard where we look at a potential competitive harm as a result of a transaction across the whole of the economy, including things like quality and labor issues. We've also seen stories in the New York Times and the Atlantic with examples of how private equity investment in healthcare results in worse outcomes for patients in some extreme examples, or worse working conditions as a result of the cost-cutting measures and the sort of efficiency-enhancing measures that private equity might bring to the table. And healthcare is this sort of fundamentally vulnerable, sometimes life or death thing that everyone needs to interact with. And so I think that all of this means that it really resonates with people and with the public, and it's not this sort of wonky antitrust topic. I think the pithiest sort of encapsulation of this is in the quotes from Chair Khan and AAG Cantor in the press release for the request for information that the FTC, DOJ, and the Department of Health and Human Services jointly issued around PE roll-ups in healthcare. As Chair Khan put it, when private equity firms buy out healthcare facilities only to slash staffing and cut quality, patients lose out. And Cantor noted that the topic is important to DOJ, quote, because of its important impact on the health and well-being of Americans.
So you just mentioned this request for information that the agencies put out earlier in the year. Can you tell us a little bit more? What's the purpose of the RFI, and does it signal anything about where the agencies are focusing and what enforcement might come out of it?
Sure. So in March of 2024, the FTC, DOJ, and HHS jointly issued a request for information requesting public comment on transactions by health systems, private payers, and that just refers to the insurance companies, PE funds, or other asset managers that involve healthcare providers, facilities, or other related products or services. And the RFI is this opportunity for the agencies to hear from the public, particularly patients, workers, healthcare providers, and other market participants, about how deals might have a negative impact either on them, on patients more broadly. Just what are their observations with following a transaction in the healthcare space that they've felt or been impacted by. And the goal is, I think, to develop future enforcement and policy efforts. And the joint agency approach, I think, also represents the whole of government approach that the Biden administration has generally taken to antitrust enforcement. In terms of what this might signal, I think it's an opportunity for the agencies to see where there might be gaps or blind spots in some of their enforcement actions to date, or might even be an opportunity to also see gaps and blind spots in sort of competitive theories of harm as well as a result of mergers. Since we are again sort of moving away from this primarily price effects driven standard to something that is more holistic.
Thanks, Carla. One issue, and you mentioned it earlier, that's gotten particular attention is these roll-up strategies. I think I've gotten a couple emails about articles on roll-up strategies in PE while we've been talking. So can you explain what this is and how it relates to everything we've been talking about so far?
Sure. So a roll-up strategy is where a fund invests in a portfolio company, and that first investment or the creation of a new entity is typically referred to as a new platform. And then the fund uses that new platform to acquire other businesses. And maybe in the healthcare context, maybe in the same practice area, but different geography, so they can expand the geographic footprint, or perhaps in different but adjacent spaces to expand the scope of services or products offered. And so the subsequent acquisitions by the platform, by the sort of base portfolio company, are referred to as roll-ups. And you might hear like roll-ups, bolt-ons, add-ons, serial acquisitions. A variety of terms are all synonymous with one another. And it's one way that private equity funds see as an avenue for growth, to take a platform or portfolio company and basically expand its footprint more broadly.
Thank you. And I want to talk a little bit more about why the agencies think that could potentially be problematic. And maybe the way to do that is to talk about FTC v. U.S. Anesthesia Partners and the recent decision there involving Welsh Carson. What was the theory and what is that, what happened there?
Sure. So this is a really interesting case because the complaint includes every civil antitrust violation except for maybe Section 8 of the Clayton Act that you could possibly have. And so what the FTC challenged here was 10 plus years of add-ons by a company called U.S. Anesthesia Partners. And Welsh Carson is a private equity fund that invested in U.S. Anesthesia Partners. They created it in 2012 as a new platform, and per the FTC's complaint, then engaged in a series of acquisitions of anesthesiology practices across Texas from 2012 through 2020. So we're talking about a long swath of acquisitions that the FTC is targeting here. The FTC alleged that U.S. Anesthesiology Partners had this sort of multi-pronged strategy to consolidate and monopolize the market for anesthesiology services in the Houston, Dallas-Fort Worth, and Austin MSAs, or metropolitan statistical areas, including the roll-up strategy of acquiring practices, raising prices for commercially insured anesthesiology services after each acquisition, engaging in price setting agreements with other independent physicians in the geographic markets, and then also entering into an agreement with another competitor to basically stay out of U.S. Anesthesiology Partners territory. The FTC complaint alleges that all of this was in violation of Clayton Act Section 7 and FTC Act Section 5 as acquisitions that substantially lessen competition. Also, unfair methods of competition under FTC Act Section 5, price fixing in market allocation schemes in violation of Sherman Act Section 1 and FTC Act Section 5 again, and then monopolization in violation of Sherman Act Section 2. The FTC named both U.S. Anesthesiology Partners, so the portfolio company, and Welsh Carson as defendants. And among the Welsh Carson entities that they named, they included the relevant fund entities, so the thing that actually invested in USAP, the general partners of that fund, the management company that helped to provide management services to the fund and to its professionals, and then the general partner of the management company. The complaint goes into a lot of detail that I won't go into here about sort of the relationships between all of those entities. But what happened more recently in May in the Southern District of Texas, the court granted Welsh Carson's motion to dismiss the case, but they did not grant U.S. Anesthesiology Partners' motion to dismiss. And what they focused on there was the fact that Welsh Carson had, at the time, only a minority interest in the fund entity had only a minority interest in the portfolio company. So private equity investment structures can involve a lot of entities and a lot of layers, and which is often driven, in my experience at least, by tax implications, and it's not like some obfuscation game for antitrust purposes. It's usually driven by tax stuff that is well beyond my wheelhouse. But here, the relevant Welsh Carson fund only held a minority interest, as I mentioned, in USAP. And the court found that it could not engage in ongoing violations of the antitrust laws through just a minority interest. And so while the FTC wasn't able to pierce the corporate veil, if you will, and bind Welsh Carson to the complaint, the case against the portfolio company continues.
Got it. That's extremely helpful context. My next question is, do you think this signals anything about the strength of FTC's theories or future challenges in this area?
So the FTC complaint is seeking injunctive relief under Section 13B of the FTC Act, which is forward-looking. It allows the FTC to bring suit where it has quote, reason to believe that any person is violating or is about to violate any law enforced by the FTC. So it's not backward looking. Although the court found that the FTC did not adequately allege that Welsh Carson is violating or is about to violate the antitrust laws, because at the time it only had a minority interest, it had sold off some percentage, I think back in 2017. It did find that the FTC alleged ongoing violations by USAP. And so I don't want to read too much into the fact that the court granted Welsh Carson's motion to dismiss. Here, one fund entity held a minority interest in the portfolio company. And again, not to get too into the weeds on PE fund structures, PE funds will use a variety of structures for their investments. And so they may pool money across multiple fund entities that may not individually hold a 50% or greater interest, but may in the aggregate have 50% or more of the interest in the portfolio company. And then those entities may or may not be managed by the same general partners. So if you kind of keep working up the chain, you may get to the same folks who in the aggregate have a controlling interest. And this case doesn't speak to those other kinds of scenarios. And with a different ownership structure, another case may be more successful for the FTC in binding a PE firm. The court's denial of USAP's motion to dismiss, though, still leaves open enforcement of roll-up strategies more generally, which I think echoes at least Guideline 8 of the December 2023 merger guidelines, talking about how roll-up strategies, effectively in and of themselves might be a competitive theory of harm. So I think the bottom line is watch this space.
With the case against USAP still moving forward, what takeaways do you think that, healthcare companies that have, added on transactions, or if you are a PE firm investing in this space, what would you be keeping your eyes out for as the case progresses?
Sure. So from an antitrust enforcement perspective, I think firms need to think about the competitive effects of their investments more holistically, and not just from the perspective of will prices go up, will payer rates go up, for example. I think roll-up strategies will continue to be tricky. We have Guideline 8 from the merger guidelines, but when are roll-ups or bolt-ons too much, even if they don't otherwise impact the competitive landscape? I think some questions to think about are, how are patients potentially impacted? How are workers and medical professionals potentially impacted? Going back to the RFI for a moment, there were over 2,000 comments on the RFI on consolidation in healthcare markets. And some of them talked about how medical professionals are utilized in a way that is meant to cut costs, but may result in sort of longer working hours, which might lead to lower quality outcomes. Some talked about worsening quality generally. Some called out specific mergers or cross-market mergers or consolidation among the payers, so not just focused on the providers. Some also called out the process for certificates of public advantage, which are largely immunized from antitrust laws under the state action doctrine. So if I kind of think about all of this in the aggregate, I think we'll see continued focus, continued investigations, perhaps maybe even directly coming out of some of these comments to the RFI, and then enforcement actions related to all of those issues in healthcare M&A.
With these, renewed and aggressive, actions by the agencies really to, double and triple down in this area of the economy, do you see any reduced, investment or potential chilling effect of investment in the healthcare sector because of the agency's focus here?
I don't think so. I wouldn't see that. I think generally what we've seen across PE sort of writ large is just more careful consideration of these issues. But investors are still going to be interested in making these sorts of investments, and will still be interested in private equity as a means for these investments. The healthcare, again, has, sort of strong fundamentals from an investment perspective. So I don't expect there to necessarily be a chilling effect, but perhaps, or at least not a significant or overly material chilling effect. Maybe there's a few deals at the margins that, somebody takes a closer look at and says, well, maybe this one isn't for us. But I think overall, it just maybe will result in some more circumspection.
Carla, thank you so much for all of these insights and being able to sum up, these complicated issues in such a easy way to understand, both for our listeners and lawyers and practically for everyone listening. It was very helpful. Before we let you go, we always like to learn a little something personal about our guests. So tell us something about yourself we wouldn't know if we only knew you professionally.
So these kinds of questions always stump me. I don't have any particular hidden talents. I definitely cannot sing. I can't play an instrument. I'm probably one of the most physically inept people and uncoordinated persons I know. But one funny story that comes to mind that I don't often tell. In grad school, I once won tickets to a Detroit Red Wings game by calling into a radio station to answer a trivia question of what were the 7 Major League Baseball, NFL, NHL, NBA teams at the time, at least, whose names do not end in S. And 3 of them are in the state of Florida, which is where I grew up, which is another thing that people don't usually know about me either. So you got a 2-for-1 here. And that's the Orlando Magic, the Miami Heat, and the Tampa Bay Lightning. And then if I, kind of think about the Lightning and think about hockey, the Colorado Avalanche played the Panthers in the 96 Stanley Cup. So I remembered them. And then you had the White Sox, Red Sox, and the Utah Jazz. So that was like my one of my crowning achievements for grad school many, many years ago.
I'm both impressed that you did that then and how quickly you can still recall it now. So that, I think you just rattled off more sports teams without ending in S that I could name with any letter. So
it gets remarkably harder, I think, if you then go into professional soccer teams. And I could not. That was a one-trick pony in that regard. I have no current knowledge beyond that.
Well, you could keep talking about it. I'm pretty impressed. Before we let you go, we'll do our final segment, the Curious Hat.
And now it's time for the Curious Hat.
All right. I will try not to stump you. How would you spend your perfect weekend?
Oh, that is okay. Perfect weekend. I had one of these pretty recently, and it would be probably being in some city. I'm pretty fond of Copenhagen, get there a few times a year, or maybe New York or Chicago. And it would involve great art museums, usually modern art, and it would involve maybe some outdoor activity. Get to Montreal a few times a year as well, where there's usually art and hiking involved. And then in the evenings, to make myself, because I to reward myself for the hiking or the other outdoor activity that I've done, usually involves a great restaurant and some great wine. So that would be a pretty perfect weekend.
That sounds great.
I'm traveling with you, Carla.
Yeah, I know. And I'm very glad to hear you had one of these perfect weekends recently. What a great way to end the episode. So thank you again, and thank you to our listeners. We'll see you soon.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.